review of the case. I requested them. If there is an issue in regards to the text messages with his lawyer, I know I objected to the subpoena. The primary purpose for objecting to the subpoena is based on the fact of attorney-client privilege. However, if you feel like it would be necessary to disclose these text messages, I believe my client is willing to do this. We just don't. We object to the subpoena ability of it, if that makes sense.
I can clarify if that would help as to why it was requested.
Yes, this was in regards to the possibility of any sort of obstruction or anything that is not in favor of acting in the best interest of Kona, correct?
It was less about that, Your Honor, and more, I'm gonna just be real, just level. So I feel that Kona has been, what's the word I'm looking for? Disadvantaged or not given effective counsel from his previous attorney, just based on the comments that were made. I did have a review of Counselor Fender's commentary as well as Titus's commentary as well, but I can't ascertain one way or the other. If that is true, Your Honor, then it's unfair to Kona, Mr. Kona, to hold that against him. If there wasn't sufficient notification of court, if the lawyer didn't do his job, that's not fair for the state to hold that against him, right? So we don't want to accidentally hold that over his head. And meanwhile, on the flip side, the true story is, basically he got screwed, right? That's why we're trying to figure out if there was any issues with scheduling and so forth. Unfortunately, it's one of those he said, she said things that, only two people know, and that's Mr. Kona and his previous attorney. And I'm hoping that, that information will be forthcoming from Mr. Kona himself. I mean, it's his choice. He doesn't have to. But yeah, I mean, if he got screwed, then it's not fair.
Right. In regards to the practice of another attorney, we can handle that after official court proceedings. As it stands right now, we allowed for a discovery period for the defense once again, simply because
it's lacked. Someone lacked it.
And information was provided to them, as well as them giving evidence to them. With all of that in mind, we're going to move towards pre-trial motions.
Just to clarify on this one, would you like the? I have it available. As I mentioned, Mr. Kona is willing to give this information. It's the subpoena ability, I think, is like a violation of attorney-client privilege. However, he is willing to give this freely of his own accord, if this makes sense. So we do have the text records, which is it's a very extensive text record of 2 texts from Mr. Kona to his attorney with no response.
Okay.
Ouch.
So
that's a problem.
That's neither here nor there in regards to the actual case in mind.
Okay, so you don't need it for this case. I just wanted to be forthcoming in saying that we'd be willing to give those.
Right. In the interest of any sort of criminal charges that may come about from those, we want to make sure that those are protected. So after court proceedings, if he decides to hand over those text messages over to SAO for further investigation, he may do so. If he wishes to enter into a civil suit with previous counsel, he may do so. But right now, I want to worry about this case and this case alone.
Okay.
So once again, we are going to move forward with any pretrial motions. This is your chance to review any evidence, get it dismissed, anything sort like that. So starting off with the defense, with regards to any evidence.
Your Honor, I feel like I would not be doing my due diligence as a lawyer if I did not address this prior to evidence. We do have a motion of dismissal based on a mistrial in regards to the fact that there was a hearing scheduled last Friday, and it was not canceled until 5 minutes after the arraigned time, when my client was already available. The reason I believe there should be a mistrial in regards to this is because on the docket it was made clear multiple times that it was extremely important that Mr. Kona arrive, and that if he doesn't arrive, that max charges should be pushed without him even being here. Fact of the matter is we were here on Friday at the appointed time, and the notification went out 5 minutes after that ordained time. So as a defense attorney, I feel like I would not be doing my due diligence if I did not present this motion.
I have a rebuttal, Your Honor.
Go ahead.
Our rebuttal is in two parts. One, the new time that was scheduled for Friday, that was not actually agreed to SAO, and as such, we didn't actually say we would be here, number one. Number two, with regards to the discovery just today, a few minutes ago, with regards to the text messages with Mr. Kona and his previous counsel, and the previous statement that we made, we were unaware of that previous issue with his counsel when those statements were made. And to hold maximum over his head because of the previous counsel's issues, we'll put it that way, again, as I stated before, is unfair. So I would say that those previous comments should be null and void regarding maximums, and that we should test the evidence as it is, piece by piece and case by case today, and offer Mr. Kona a fair trial.
So, while I understand your concerns on any sort of prejudice towards your client or anything sort like that, we were initially under the pretense that your client was either fleeing the state or choosing not to appear before court. For that reasoning, we had put a stipulation that a bench warrant be put out for him to appear before a court. Otherwise, the case would have been defaulted. As it stands, he did appear. He pertained to counsel, and we are able to meet here today in regards to that. While I do apologize for the late notification on that day, things in life happen, and things take us away from our abilities to always be available. So I would like to, at the very least, try to hear out all the evidence, and we will take into consideration on your client's willingness to appear before court.
Understandable, Your Honor. Thank you. Like I mentioned, I have to do my due diligence and bring things like this up. So if you're wanting to, then we can move into evidence.
Okay.
Also, Your Honor, the state would like to offer its apology to Mr. Kona as well for the previous belief. We had limited information at the time, which has now, I believe, to be proven wrong, just based on the information from Counselor Fender. So we do sincerely extend our apologies.
Understood. So we will move on with evidence. Does the defense wish to call the question or expunge any evidence brought forward by the prosecution?
Yes, Your Honor. This is going to be quite long, so we'll go piece by piece. Number one, evidence entered under Alpha A witness testimony was the statement of Tristan Tate. We wish to have this thrown out based on the fact that it contains a lie that has been affirmed in regards to evidence that we submitted with the first subpoena. Our first subpoena, Mr. Tate, neither Tate owns a Bugatti, and both of them are claiming that this incident revolved around the Bugatti that they owned, making these false statements, therefore compromising the entire integrity of the testimony.
Prosecution?
We have a rebuttal for that. Regarding that statement was made back in August. It is now 2 months later. People buy and sell cars all the time. It is highly possible that the statements made by Andrew and Tristan Tate were accurate at the time of writing, and they simply sold their vehicle.
Your Honor, it's on the state to prove that at that point. This is merely me showing that there is a discrepancy within their statements.
With respect, the Tates are not on trial here. We don't need to prove anything with regard to that. It would be on the defense actually to prove whether or not that the material is of the statements that they made.
Which was done via subpoena.
Correct, but
and a signed statement by an officer, Your Honor.
Yeah, but unfortunately that is well after the fact, Your Honor. Again, we'll still stick with what we stated, that it is simply a matter of they just simply sold their vehicle. There is absolutely nothing else that would suggest that they haven't sold the vehicle or that they did sell the vehicle or any way, shape, or forward. Like it's silly. I mean, do I now need to track all vehicle sales for every single vehicle dealership as SAO in order to avoid this kind of argument in the future? I don't think so.
Pointing out the discrepancy in somebody's statement is Pretty basic.
It's a good attempt, but at the end of the day, there's nothing that says that they never owned the vehicle to begin with, and thus that their statement is false. Certainly, they could be called up as witnesses to ask them that question.
Which they are indeed on the witness list for that. So, in the interest of moving things along, we are going to allow this piece of evidence simply because Councillor Augsburg is right. The transfer and sale of vehicles do happen quite often. While it is a discrepancy, we are talking 2 months' time here.
Well, then, Your Honor, then these testimonies should be thrown out, and then the testimonies that they bring forward in court on the stand should be what holds. The fact of the matter is that these don't pair with this. And then also would bring my second point of discrepancy here. The medical records submitted for these two also mention that there were knife wounds. However, the statements say that they were shot, Your Honor.
Prosecution.
With regards to the statement, Andrew Tate was in fact shot, quote, through and through, GSWs to the leg. Local docs had stitched up both wounds. Nothing was broken. Bandaged GSW.
Your Honor, there is nothing here that shows which of the individuals was shot supposedly by the people on scene. So therefore, it could be assumed that either one, and thus implying that we don't have a clear understanding of the situation based on these statements because they don't match both medical records.
Your Honor, we do have forensic evidence on scene that a firearm was discharged multiple times from the defense.
And a medical statement that says they were stabbed.
One of two.
Right. In consideration of both pieces of evidence, please wait 1 moment while I cross-reference it with other pieces of evidence that are in relation to it as well. In regards to the statements, they do correspond with the injuries as well, with one of them being shot and the other one receiving stab wounds, if I'm reading this all correctly.
The statements say that they were both shot.
Statements
To quote,
say-
and then shot us in the shoulder at the sorry, I have trouble with this. The shoulder and stomach. Then the cops came and shot back.
We'll offer to strike Tristan his medical and his statement, but Andrew shall stick.
Understood. We will strike Tristan. It's the one that you were wishing stricken, yes?
Yeah, we could start with this one.
Okay. We will go ahead and strike those from the record.
Okay. Consider it done, Your Honor.
Now, next piece with Mr. Andrew Tate's statement. I would like to object to ejection on creation of material fact. The fact that his statement says that 4 ballas were who fought him or shot at him. This is a creation of material fact because there's nothing that shows that these were specifically Ebolas. There's also no collaboration within his statement that states that these are Ebolas.
Prosecution?
1 moment, Your Honor. I believe that we can ask for witness testimony later in trial in order to corroborate that statement.
Understood. We'll go ahead and only strike the parts in regards to Ballers from the record.
Oh, that's actually the part that we'll be discussing in trial, Your Honor. Eyewitness testimony of what they saw and what they believed is something that they can be asked on the stand and then cross-examined on.
Well, and then that is the testimony that will be taken, but the fact still stands that this testimony should not stand because it specifically has creation of material fact in it. So you strike this, and then you put him on the stand, and he can say whatever he wants then.
It can be referenced to, however, for consideration, we'll take it as what the witness states here on the stand if they are present.
How about this? I'll throw the defense a bone. We'll strike both of those, and yeah.
Okay. Okay. In favor of making sure that we do have all the facts available to us, you may call these pieces of evidence in for cross-examination, but it doesn't necessarily equate to a witness testimony.
Sorry, run that by me again, Your Honor.
You can reference to those statements, but we won't take the statements made here on paper as the witness testimonies that they are here and present to testify.
Oh, we'll just make it simpler than that, Your Honor, because it's going to be a lengthy trial. For Tristan and Andrew Tate, we'll just strike them completely. So their medical record as well as their 2 testimonies.
Okay. We'll go ahead and get those strict from the record then.
Thank you.
Don, Your Honor.
Thank you. Defense, next piece of evidence.
Your Honor, I would like to go to evidence piece A2, photo of the crime scene. If you take a look at this photo, it specifically shows that the scene is not properly contained. They only have barricades placed on one part of entrance exits. Therefore, this is not a contained scene, so it cannot be labeled as a crime scene photo.
Your Honor, at this point, we're getting to the SOPs of the PD as well as SAXI. That's under investigation today. Also, realistically speaking, barriers can be run over. You can clearly see that there are tire marks coming from the same direction that the council has just indicated. You can also clearly see that there are bullet marks in several vehicles, as well as a Bugatti that's sitting right there. And you can also see a vehicle down by the traffic light, also ready to roll through the intersection. The fact of the matter is, Your Honor, when there is gunfire and when things get a little hot and heated, people will drive through barricades, civilians, EMS even if they need to in order to get to a medical. That particular argument, sorry, at this point, that's arguing on circumstantial at best.
Your Honor.
Also, I do believe that we have Peter von Karma here in the courthouse. He's currently doing bar exams, but he himself processed that scene, and we can call him down, and he would be more than welcome to talk about how that scene was handled.
Your Honor, making the statement that their processing is not on trial is very concerning, because that's literally what the criminal trial is calling into consideration things that happened. As Technician Oxberg just mentioned, there were vehicles rolling through the scene, which contaminates the entire crime scene. So not only has the evidence here show this, should be thrown out because of this, he just testified to it. Well, not testified because you're not on stand, but he just verbalized this.
Right, and while I can understand your point of view, there is a level of understanding that we need to give as well, such as this is a very active area and a roadway to even speak of. So, while containment can be called into question, it's not the purview for us to tell them how to do their jobs, only to observe the evidence as is presented to us in order for us to determine its validity.
Understandable,
Also,
Your Honor.
Also, Your Honor, it's entirely a question as to when the photo was taken as well. It could have simply been taken after the barriers were removed.
Oh, so it could be taken after the crime scene was compromised. Perfect.
In short,
No, that's not
The
what I
evidence-
said. I said after the barriers were removed.
Order.
Please do not put
Order.
words in my mouth.
in short, evidence is going to stay.
Thank you, Your Honor.
All right, Your Honor. Next piece of evidence. We are looking at Alpha 4. This would be the casings. We look to have every single casing listed here strict from the record.
On what grounds?
I have that here for you in a moment. All right, going back to precedent set in CR-20220915 Alpha, summary judgment state of San Andreas versus Leo Morales Kyukyo. There must be a clear documentation chain of custody provided. The only thing that this shows is a grouping of casings in a picture with somebody's name on it. It does not, there's no affirmation form or anything written down clarifying who processed the scene or who ran the forensics on this evidence. This is actually a precedent set by you, Your Honor, that specifically states that there has to be a actual documentation to accompany the evidence.
We'll object to that, Your Honor. There is, in fact, who processed the forensics. It's literally in the same photo, Peter von Karma.
Name on a placard does not prove who did this. It does not state who did this, and there's no signature on this. If you would have done merely an affirmation form and stated who picked up the casings and then who ran them for fingerprints and then signed the form, I would say that it would add to the legitimacy of this. But this is just some PowerPoint placard.
We are getting into the specifics of our SOPs and our processes and procedures.
This is not an SOP. This is chain of custody. Very important.
Your Honor, we do not write affirmation forms for every single forensic scene that we go to. That is simply not what we do, nor does the PD do that.
Just because you don't doesn't mean that it shouldn't happen.
Any officer that is here in this very courtroom can be summoned to the stand. And in fact, we have several SACSI members who can be called to the stand to testify to that exact same fact.
2 months after. The fact of the matter is that there should be clear documentation the day of. All we have here is a PowerPoint slide with somebody's name on it with casings.
With fairness, Counselor Fender, that is not a PowerPoint slide. That is a tool that was designed and produced by the PD in order to assist the state in prosecuting crimes that happen in our state.
To call it any...
Your Honor, at this point, I'd like to have the counselor censured. I'm trying to speak here, and I just keep getting interrupted.
Go ahead, I'll let you continue.
Thank you. That is known as the MDT Guru. That is a tool that is used by the PD and produced by the PD in order to organize evidence so that we don't have to upload a single image every single time, which would result in hundreds, if not thousands, of pieces of evidence. That is an organizational tool. The bottom line is that information that is there was signed off. That is Peter von Karma's signature. And if you would want to call him to the stand, by all means, you can call him to the stand and ask him, did you call these forensics into question? Did you look at these yourself? And he will answer in the affirmative. We have done our due diligence in doing the evidence beforehand. To ask this now, well after the fact, is silly.
Your Honor, I still ascertain that this is not the signature. This is merely a document provided that just has a name on it and then a time at the end of it. All chain of custody should be done in the moment, and technically a chain of custody should be completed when you pick something up, when you transport something, when you do forensics on it, when you put it into storage. I'm not asking for something that insane. I think merely asking for an affirmation form after a crime scene is processed that clearly states who exactly picked up the casings, who exactly ran the forensics on them. I think that is more than reasonable enough, because you can't sit here and tell me that multiple people don't pick up casings at a time and then they put it on one single placard. So I think asking for an affirmation form in regards to the precedent that you set, which clearly states that documentation, clear documentation on who processed specifically each piece is needed here.
Okay, please wait 1 moment. Trying to figure out which precedent he's referencing to which case. Could you state the case in which this precedent was set once again?
Yes, it's the one that you presided over, CR-20220915-A. And it specifically says the chain of custody is important to any case. We need clear documentation as to who handled what piece of evidence for any incident.
What was the name of the case?
Your Honor, I've sent it through
Oh.
to you.
Summary judgment versus summary judgment, State of San Andreas versus Leo Morales.
I've also sent it through to yourself, Chief Justice.
Just so that we're clear as well, that was also prepared by me using the exact same tool, and that was ruled as the evidence would be held. So, I mean, if the counselor wants to review their argument, please feel free.
That's not what was referenced in the precedent. If
All
that's
right,
what you want to go, that's a completely different piece of information.
While the justice is considering the information, behoove of both counsels and parties to not speak and make arguments additionally.
Yes, Your Honor.
Understood.
Thank you.
Would a recess be in order, Your Honor?
That is up to Hawthorne.
No.
Give him the chance to think. 'Cause he didn't have
Yes.
a chance to think while people were just talking.
So just want to get a clear statement that it was Peter Von Karma that processed the scene itself. Is that correct?
This is great.
There's
Yes, Your
nothing there that shows that, Your Honor.
The documentation that is provided to us through this picture is signed off by Peter Von Karma. And while it does not document where every single bullet casing is found, it does reference to who the evidence that is provided via photographic evidence.
Your Honor, you just asked them a generalized question if he did it, and they just said yes. This doesn't show that it was actually him on scene. That's why I'm saying an affirmation form is needed, where it specifically states that this is the person that picked up the casings, and this is the person that ran the forensics on them. Merely putting a name on a generalized entire accumulation of casings does not show that and does not sign it and make it actually like verified. Anybody
Then-
can put these onto a slide here.
Then you may ask Peter Von Karma to the stand and ask him the direct question as well.
So he wants us to take pictures
So-
of the person
Jason,
doing.
Hello?
shush. Sorry about the outburst, Your Honor.
Mm-hmm. So,
So just to clarify, you're ruling that chain of custody can be proven hours after the fact by just having a name on something with all of the compiled evidence from the scene and doesn't need to be attributed to the person in chain of custody. I think we have different understanding of chain of custody, so I just need it clarified for me. Because this isn't clear documentation, I guess.
you do
is my
raise
concern.
very good points, and I do need to address them. But for now, I'm going to allow the evidence to stand for now. I'm going to take it under consideration for my ruling.
Okay, thank you, Your Honor.
Okay. Moving forward. Any other evidence that you wish to be stricken from the record?
Oh yes, we're still on instant A. All right, so we're going to go to A7 and A8, the medical records of Gabriel Rizzo and Andre Oxburg. I wish these stricken from the record as they have been manipulated and are not the full medical report. Personal identifiable information that would attain these back to the individual has been removed from the documentation there, and they have been redacted. If there's concerns on release of personal information, there is the opportunity to seal. However, they did not do this and they manipulated these forms, so they should be removed from evidence.
Objection, Your Honor. At this point, the counselor is grossly out of line. This has not been manipulated. That is a very serious accusation. That information has been protected under HIPAA, which is standard for any medical record. You can open up any single court case whatsoever and look at that information. We redact ICE contacts, date of birth, and phone number. That is it. Any other medical information that doesn't pertain to the scene in question is also covered under HIPAA, and I suggest that you go over to Schultz and ask them about what HIPAA covers and doesn't cover. To suggest that it has been manipulated indicates malice.
Your Honor, since
Be very careful, counselor. Libel and slander laws are a thing in the state.
date of birth and phone number are not covered by HIPAA, Your Honor. So although he wanted to jump on that fact, that is all I am talking about, is that the personal identifiable information at the top, which is not covered by HIPAA, has been stricken. Also, HIPAA applies to the release of information from the hospital in regards to those manners. However, here it's been clearly posted on the docket. So if we're talking HIPAA, like that would be a violation there, but I'm not pushing that. I'm saying that the top of the form with the personal identifiable information that specifically says that this form goes to this person has been changed and redacted. So therefore, because the personal identifiable information is gone, these forms are not valid as evidence. Yeah, if there was concerns of the leakage of information or HIPAA violations, they should have been sealed in the first place.
Okay, so I have actually studied HIPAA extensively, as I used to be one of the lawyers for Schultz, formerly known as Phillips. So I can tell you that what is provided to us is something that is regularly done by anyone providing medical records via medical records from Schultz. The only things that should have been redacted in regards to this should have been the treatment. However, if the goal of PD here is only to reference to one single incident, they may redact any other information in regards to that as to protect a person's personal information. Because that is the true essence of HIPAA. It is to protect a person's medical information from being spread to the public.
Exactly, Your Honor, and I'm agreeing with this. I'm not talking about those portions of the medical record. I'm talking about the personal identifiable information that attaches this record to the individual.
Right. And those are still protected by HIPAA. Even when I go to Pillbox, back when I was a lawyer requesting medical information, the date of birth and phone number were redacted because those are protected information by HIPAA.
However, at this point, it has been entered into evidence to be used, so it opens it up for discovery, and it should have been used. Because now you could just put any form with somebody's name on it and say, oh yeah, we don't have the information there because of HIPAA. And it could be attributed to anybody.
My date of birth and my phone number are well known, number one. Number two, I'm not the one that's on trial. Nobody needs to know how old or how young I am. This is absolutely ridiculous. I think the counselor is grossly reaching.
This isn't about who's on trial or what. It's about the evidence that was provided, literally having redactions on the portion that attributes that form to the person.
Right, and as I've told you, those are allowed to be redacted. So the evidence is going to stand.
So how can we attribute this to the individual if the actual things that tie the record to them are being redacted?
I think the counselor should have a look at first name and last name, which are clearly visible.
As it stands, we can attribute the medical record to Andre Oxberg. And if this is called to question, you may call a medical expert to the stand if we do have one readily available.
Okay. We are not filing any motions at this time for Alpha 5 and Alpha 6, just because they're statements. There's nothing that we have seen that's like extraordinarily egregious, like the vehicles or anything like that with the other statements. So we believe that these should stand until they can be called to the stand. Moving forward, I motion to dismiss all charges under Exhibit B. give me a second to move up. The shooting of Jack Carter. There is literally no evidence that has been submitted for this.
We'll agree to that, Your Honor. Make it simple.
I think
Okay.
there was. I think you had good. I'm not saying that you did that on purpose. I think I understand the reason. I just.
Yeah, we requested a statement from former Trooper Jamie Stone, and they declined to provide a statement. However, at the time, the charge was listed, and I have to leave it there until it is either upheld or struck.
Yep. I
Okay.
think we're
So
both
yeah,
understanding
we
on that
will.
one.
Yeah, we will withdraw that one from prosecution for sure. It's not an issue.
Okay, officially any charges regarded to evidence block B, shooting of Jack Carter, will be dropped.
Noted, Your Honour.
Give me a
Moving on.
moment while I. Sorry, there's so much here. I go back forth.
No, I understand.
All right. Evidence block C, murder of Camila Martinez. We look to strike every single pistol casing and DNA swab of evidence from this in regards to what I brought up earlier with the same precedent. And this, we don't have a, what do you call the, you don't like me calling it the PowerPoint. I was doing that because I didn't have
The tool. We don't have the tool sign off on this one.
just a tool, okay.
We'll just.
Well, I just wanted
simplify
something
this.
to reference them, so like, for them, so like I don't reference it wrong.
I can attest that
Evidence,
I personally
see
processed
one.
that scene myself with my own two hands.
There's no documentation, which, as per the precedent,
You can
there
throw
needs to
me
be
up on the
clear
stand and swear me under oath.
That's not what it's about. The documentation of evidence was not provided, which has to be provided as part of chain of custody. Chain of custody is not a statement, it's documentation.
Yeah, looking over
Can
this
we call a
site.
recess, Your Honor? 5 minutes, please.
Very well.
I think there's some
Well-
things that need to be discussed.
And the sort of 5-minute recess will be going on then.
Thank you.
Court is in recess. We will
Chambers.
resume at 1:15. That is 1:15. Court is now in recess.
Damn, I know who I'm getting my
Is
lawyer.
that a jerry can?
Yo, fuck.
Yo,
I'm sorry.
My lawyer when I
Yo.
try to get Kona.
Yo, what?
Dude.
What?
do you sell houses?
Mr. Malk, did you bring a jerry can in here?
Yes.
I don't know what you're talking about.
Pun. I can't quite hear you.
That trailer. I want that trailer.
Okay. How much do you want to bid on it?
This is 120 grand. I'll buy it, man. I'll buy it.
No. It's an auction.
The fuck? No, I just want to buy it.
Well, you can't.
Hey,
That's not
what's
how it
going on?
works.
Bullshit. Right, you're under arrest.
Okay. Feel free to arrest me whilst I'm doing my job, officer.
So I forgot a bid on it.
What?
121 grand. There you go. Boom.
121. Okay. Write me an affirmation form with with.
I forgot to do that.
Yes, you do. We have to have a list of evidence to go by, mate.
Oh my god. So stupid.
What do you mean, so stupid?
That's a bad.
Mate,
Hey,
listen. Right, okay.
The winning side.
The trailer. I forgot.
It's number 4, Senora. Hey, Vinny.
Boom.
Thank you. I'll get that sorted for you. Vinny!
You want me to go into the cola machine? Ew. Okay. Swear to God, it's the photo is me on top of a cola machine. I'm Canadian.
What do you need from me?
The affirmation that you posted, can you put it in the folder that I put in clerk chat, please?
Oh.
The unredacted version, please. I'll get you an account sorted on the site in a sec.
Favoritism. Welcome to the DOJ.
I've had some comments.
Just no leaking.
There's not going to be any leaking. Anybody leaks it, they lose their job.
Fish in there.
Right, thanks. I'll get that processed and then I'll get you a login.
You need food?
I'm good for now, thank you.
Okay.
I'm going to need.
Go get him, champ.
Alright. I have cheese pizza and E. cola.
Okay, that works.
Craig, you're slipping.
Thank you, Vinny.
No problem.
You okay?
What are you doing? How's your leg, Danny?
It's you know, healing. What's what on the floor?
It's you. The recorder's on the
Oh,
floor.
somebody bloody knocked it off the desk, didn't they?
This guy keeps smoking in the courthouse.
I'm putting it here.
Shut up, Blue. You dumbass.
Yeah, if you could pick it up for me, that'd be fantastic. I can't bend down at the minute.
You're fine. Put it right here.
Cheers, mate.
Right here.
We're ready when you are, Your Honor.
Okay.
Oh, bollocks.
Oh, we're ready as well, Your Honor.
Whatever.
It'll do.
Okay. Clerks, are you both ready?
Yes.
Yes, Your Honor. Just ignore the flashing red thing in the middle of the floor.
You know, that's fine. Okay, calling court back into session. We were in the midst of discussing the chain of custody in regards to evidence C1, correct?
Yes, because no clear documentation was provided in the evidence in regards to these casings. Just casings thrown up on the docket, Your Honor.
I'd like to point out that the counselor did submit a subpoena, their second subpoena, which they later retracted, in which they asked the PD for all evidence and case files and such forth, and later retracted it. We had actually prepared that information for the counselor before they retracted it, but of course they've since withdrawn it. That being said, they will clearly see that it has been documented in the same case on the same day. It was done by myself, and by all means, throw me up on the stand, and I'll testify under oath that I personally collected those casings, prepared that specific piece of documentation, and it was done with my own two hands.
Your Honor, he's referencing evidence that they did not submit, so this can't be used. This is the point of this. They should have done their due diligence. Please don't interrupt me if you are going to transit. Thank you. So basically, we are presented with this evidence before us. Discovery is closed. They did not provide the burden that they need to keep this. They did not provide the chain of custody that you ruled in a precedent is required to uphold this evidence on the docket. Trying to go back on it and say, oh, we can testify to it. Testify, once again, is not clear documentation because it is something given after the fact, not during the processing of it. This directly attributes to the precedent that you yourself set. So this is cut and dry here. It's literally just casings.
As it stands with the case that he is referencing to, there does need to be a documentation as to who handled evidence and such. While the evidence itself is clear as to what it is, it does not document who collected it or who processed it, which is something that is important and is part of standard lawyer training when it comes to an argument as to where evidence does come from.
So, Your Honor, was that you acknowledging the strike?
I am acknowledging the strike, but I do need to double check on some things real quick. Right,
and
so
in that
please
case,
stand
Your
by
Honor,
for
then
just a
we'll make a
minute.
motion for immediate continuance, indeterminate at this time. Minimum 1 week.
Wait, what did I just hear?
Motion for continuance, Your Honour.
How do you feel about that? Which piece of evidence is this? Is there still dispute over the bullet casings?
It's dispute to the chain of custody because it's not documented.
Well, I mean, if you see his point on that one, then maybe this one should go. So, I mean, if they weren't prepared to go to trial without getting some pieces of evidence stricken, then why should they ask for continuance? It seems like a lot to ask at this point, especially since we're already this far in. I would tell them wrap up evidentiary objections and get on to meat and bones.
Vroom, the front row, come here.
I don't think it continues.
Vroom, my child, come sit on my lap.
We waited long enough to get this case fixed. So, I mean, I'll leave the decision up to you, and I will not begrudge you any decision that you make, but that's just my personal advice. I will shut up now. I'm sorry.
No, you're fine. Okay. So, before taking a motion on the continuance request, I'm going to make a statement.
Can you speak up, Your Honour?
I do apologize, I was whispering there. Before considering the continuance motion, I am going to put a stipulation on evidence C1. Because it does not document exactly who collected it, where, who processed it, anything sort of like that, I understand his point of view. And while it will be partially upheld, it can be referenced to as it is something that is documented here for us to see. So, in regards to evidence C1, it may be referenced for any sort of questioning towards officers, anything sort like that. However, it cannot be directly referenced itself for arguments, if that makes sense.
Your Honor, you set a precedent that evidence to be upheld has to have a chain of custody. So you're acknowledging that there's no chain of custody, but now you're saying that they can still use it. This is where I'm confused on this matter. Can you please clarify? Because that's very concerning then.
So, in short, Investigator Oxberg himself is claiming to have documented the items. Therefore, if he is able to be hauled to the stand, which is your right to do so as the defense, or even the right of his second chair to call him up.
Your Honor,
Which he
that's not a
was
chain of
originally-
custody. Oops, sorry, I thought you were done.
Which he was originally listed as a witness on the witness list.
So he can't testify to this because it was already deemed that he cannot testify.
It wasn't necessarily deemed that he wouldn't testify. He rather stated that he would strike himself from the witness list, just in favor of fairness.
So he can't testify.
Your Honor, in fairness, we were here with Counselor Zell, and the argument that Counselor Zell made was actually a misrepresentation to the court. What they had stated was that I couldn't testify.
Oh, can we hold? Can we hold? Sorry, can we? We just had an issue over here. Don't mean to cut. I wasn't trying to.
Did he?
Yeah.
Did he fall asleep?
Yeah, I think he fell asleep.
Okay.
This binder's very comfortable.
Yeah, I don't blame him.
That
It
is-
is comfy.
Okay.
Petition Oxburg, he's back.
Okay, allow me to try and make this easier. While I will be striking C1 from the record, and itself, I'm going to be able to reference to it personally when it comes to any other pieces of evidence that are provided on the docket here. It does not necessarily mean he is guilty or anything like that. It's just for my personal reference, one way or the other.
I mean, Your Honor, in fairness to the defense, if you're striking it, you're striking it. If you're not, you're not. Like that, I echo the
then I am
counselor.
striking it from the record. Then I will be
Okay,
striking
then we will uphold our motion for continuance.
And the reasoning for the continuance?
At this point, Your Honor, there are grievous accusations and issues with the counselor's statements, and they need to be thoroughly investigated. The issue here that we have is... Sorry?
That's not pertinent to this case. If there's accusations being made, that can be investigated afterwards. But when it comes to this case in particular, I would rather...
Okay, I'll just spell it out. The use of a paint program in order to organize evidence as evidentiary arguments to dismiss is ridiculous, number one. Number two, the counselor did request a subpoena of all investigative files relating to the client's guilt or innocence, which we'll happily provide to the client, but we need time to assemble that information, at least 1 hour. Number three, this case has already been going on for quite some time today, as well as previous
counsel,
days.
the client fell asleep again, if you don't mind.
Yeah.
We do have a record going, so let's just continue on.
There are conversations which need to occur which cannot occur in this courthouse, is what I'm trying to get to without destroying some structural walls, if you catch my drift.
Objection to that, Your Honor. I merely asked for an affirmation form dictating who collected casings and then who
I'll
ran the
write one right
forensics
now.
on that. That's after the fact. That's not what a chain of custody is. A chain of custody is validating the evidence in the moment to ensure that it was properly collected. This is very common across all courts of America, of the United States. In fact, more so that it's normally, like I mentioned, upon pickup, upon transportation, upon change of hands, and upon storing it. I didn't ask for any of this. I know that that is like a pretty crazy burden for what we are doing here today. All I'm saying is that having it on some presentation format, it was not enough. I also, once the Justice Hawthorne made his representations of this, stated that he would uphold that for now and I could question it later. I didn't push it further. This piece of evidence, C1, literally is a completely different presentation of the other matter and doesn't have any documentation with it. So I don't know what egregious claims I have made or what horrendous things that I have done. So I don't agree with the statements at all. I think it's all been fairly straightforward, the things that I've requested. And they're all very easy to produce at the time. If you're producing these things 2 months later, that's not a chain of custody at all.
There's still a motion to rule on, Your Honor.
In terms of the continuance.
Yes, Your Honor. If the counselor wants the chain of custody, I'll happily provide it to him.
It was not provided in evidence. This is what we were ruling on. You had a month to do this.
With due fairness, counselor, we never provide the chain of custody on the evidence,
Okay.
the entire... Your Honor, no. Either rule in the continuance or let me speak, please.
I was going to rule on the continuance.
Thank you.
As far as the continuance goes, I'm going to deny it so we can continue on. Counsel Fender, in the interest of time, let us
Okay,
try and
then in that case,
convince-
Your Honor, the state drops all charges. Court adjourned. Congratulations. You let a murderer go free. Have fun.
Oh, he mad.
Yeah, baby!
Mad.
Great, come back!
All right. Well, thank you for your time, Your Honor.
My boy free!
Free my boy. Free my boy.
He is free! He's literally free!
Get him out of here.
Hello,
I knew he didn't do nothing wrong.
stand by.
They
for
just dropped all
a
charges
few
against you.
moments here.
I don't think
Yes.
he made the motion.
Don't ask why. Just go. I knew you didn't do anything wrong.
I know you didn't murder those 47 people back in 1995.
You'd never do anything like that. Maybe in 2003.
All right. Does anybody want to buy sweets?
Hey, cocaine, anyone? 1K per bag. Alright, hold on, excuse me.
I'm saying break that, you know what I'm saying?
Who will make a law?
Whiskey 100 from Whiskey 507. Courthouse now, please. Yeah, code
C-
please.
can can you pick up the recorder for me, Vinny?
Yeah, I
Can't reach
can.
it.
Also,
think he's gonna
a
put
further
that on the
discussion
docket.
in regards to evidence
just
can
gonna
be held in a
say
more
what he's-
private setting next time.
Your Honor, I would like to mention that the state dismissed all charges before leaving the courtroom. And I feel that because that statement was made by the first chair all that should be honored and all charges should be dropped. It was very
If he-
publicly declared to everyone that all charges were dropped.
Right. And while I understand your point of view, I also need to understand that Councillor Oxburg again was a misrepresentation of the wishes of the state here. At least that is the firm belief that I'm holding on to at this moment.
So, okay.
So I just want to make an understanding that we'll evidentiary arguments in a more private setting next time, so we can have more court decorum in place.
I feel like nobody in. I
That's
feel like
not right.
nobody out there like had any outbursts at all. So I don't get courtroom decorum. I'm
But
sorry. I'm
there
I'm not
was
following.
there was a single outburst, but as I said, I'm
Oh, yeah,
understand
by
what
the
Councillor-
state. Okay.
Yeah. Like a single outburst wouldn't necessarily be representative of this, but because it was a member of the court that did have a major outburst, I do need to have consideration for who the state either would want to represent this case in the future.
Okay. So just so it's officially on the record, I would like the motion to dismiss the case based on the first chair stating that the state drops all charges, just so that I officially put that on the record.
We will have that officially placed on the record.
That is noted, Your Honor. Yes.
Thank you.
Ain't no way the
But
first
we
should
will-
just get away with that.
But as I said, we are going to just have this on a temporary hold, so that we may convene in a more private setting next time for evidentiary discussion.
Okay, but I assume we're proceeding forward as discovery is closed, we're good, and then you will set
Discovery
up
is
another
closed.
time.
We're
Okay.
good.
So delayed once again.
Yeah.
You guys are proving his point of why he wants to have it. And shh, please.
Sorry, sir.
So court is adjourned once again. I do apologize for not having this handled today, everyone. However, we want to take this as seriously as possible.